With mandatory surveillance laws still on the books in California aimed at pushing FFLs out of business, we are continuing our lawsuit to get these struck down. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we are back on Richards v. Newsom, which was our challenge to the mandatory surveillance for FFLs here in California and the consequences that have come afterwards. To walk us through some new developments in the litigation today, we have in studio, he is a partner at Michelle & Associates. You'll find his name on a lot of two-way litigation. That is Josh Dale. Josh, thanks for being with us today.
Thanks for having me, Kevin.
Absolutely. So if you can, for those who may not have been following along, the last time that we visited this was actually at the courthouse in, I believe, it was either Santa Ana or Pasadena, where we were looking for an injunction on this law. Can you kind of bring us up to speed? What's happened since then, and what's led us to today and the new development we got here?
Yeah, absolutely. So when we last spoke, we had been asked by the court to do some supplemental briefing on some issues that got raised at oral argument, specifically the issue of the applicability of the law to gun shows and the issue of home-based FFLs, which a majority of FFLs in California, surprisingly, are home-based. People doing primarily sort of niche businesses. So we did the supplemental briefing, we crossed our fingers, and lo and behold, about a month and a half later, the judge said, no, I'm sticking to my original ruling. The state at that time, in their supplemental briefing, took the position that the law does not apply to gun shows. And so the court said, yeah, it doesn't apply to gun shows. I agree with the state. And the court said, as to home-based FFLs, well, you're getting into a highly regulated business, so you're buying the privacy intrusions that this law is imposing on you. So that, an unfortunate outcome. In the meantime, following that, a case came out from the Ninth Circuit called Doe v. Bonta. And Doe v. Bonta was a challenge to a law that allowed the Department of Justice to share information about gun owners with the University of California, Davis's Gun Violence Center. It's run by a gentleman named Winnemute, who often provides expert testimony on behalf of the state in these Second Amendment cases. We've certainly seen him and opposed him when we've been doing these various challenges. So another group, not the CRPA, brought a challenge to that, and it went up to the Ninth Circuit. And the Ninth Circuit said, there's no violation of law here, no violation of the Constitution with sharing this information. There's no equal protection violation. There's no violation of the Second Amendment. And there were a couple other issues. Well, that had an impact on our case, because one of the things that we were alleging in our complaint, and it was part of our preliminary injunction, was that these recording laws in Richards violated the Second Amendment and violated equal protection. They singled out gun store dealers, as well as individuals who go to gun stores, for specific and what we considered unconstitutional treatment. And then the other thing we alleged was that it also violated the Second Amendment because it tended to chill people's expression or their ability to engage in Second Amendment activities, because people go to gun stores and gun shows to talk about a lot of things besides just, I want to buy a gun. So we have decided as a group that we were going to amend the complaint and remove the equal protection and the Second Amendment causes of action and proceed on the other claims that we brought. And in the meantime, the state had filed a motion to dismiss the entire case, basically raising the same arguments that the court used to deny our motion for preliminary injunction.
So what exactly is equal protection, and how does removing it as part of the complaint increase your likelihood of getting the outcome you want?
Well, so equal protection is something that arises under the 14th Amendment, or the 5th Amendment if you're dealing with the feds, that basically says that you have to treat everybody equally, and there are different classes of how the right is applied. Classically, equal protection is seen as a race issue or as a gender issue. So, for example, the state can't pass a law saying that, well, men are allowed to apply for this state benefit, but women cannot. That would be subject to an equal protection challenge. There is something, though, called an equal protection class of one. and it's subject to less protection, but nonetheless, in certain instances, you can say, well, this is a constitutional violation because they've singled out a specific group, not based on what we call suspect classifications like race or ethnicity or gender, but based on something else that we consider impermissible. And usually that is judged under a much more deferential test to the government called the rational basis test. So what happens is you say, okay, they're going after gun owners here. We think this is an equal protection violation, or they're going after gun stores. We think that's an equal protection violation. Gun stores and gun owners are not a suspect class. They're not one of the enumerated race, gender, religion, etc., that are traditionally protected by the Equal Protection Clause. So we say, but nonetheless, we think that the government's motivations and the outcome of going after gun stores and gun owners is so suspect that it won't even pass the more deferential standard that is applied in equal protection cases. And so that was our argument that we brought initially in front of the court in the Richards case. And of course, Doe v. Bonta sort of shot that out of the sky. So.
Right. I'm also kind of curious for you to go into a little bit further explanation on what this law actually is, means, and does. So we were talking off camera a little bit, and you were kind of describing to me the possession factor of the cameras that are being asked to mandatorily be put up in these stores. Can you go into that a little bit? Because I'm sure there are plenty of box stores that already have surveillance systems. Right. And, we've talked extensively about the cost to storage that a lot of those places might not already have. We've also talked extensively about just the intrusion of maybe a home FFL. I'm sure that weighs a lot into the arguments. But as far as being able to use those cameras, so if I'm a box store, I already have a camera in existence. Does that camera get taken over by this law?
Well, it's kind of up to the store owner. The way the law reads is you're obligated to install, for essentially the government's use only, an audio and visual monitoring system that has multiple angles, including doors and any place where gun sales transacted. So a significant number of cameras, probably more than most stores currently have with their own security system. And of course, there is the audio factor that almost no stores that I'm aware of had that before, because primarily it's a privacy violation in California. California is a two-party consent state when it comes to recording audio conversations. And so no store that I'm aware of, whether you go to a grocery store or you go to a gun store, their security system won't have audio monitoring for that purpose. This law, however, creates an exception. And in fact, when these systems have to be installed, you have to put a sign up that says, by the way, you're being audio recorded. That's how they address the otherwise public policy against non-consented to recordings. But what this law requires is you put up all these cameras that include audio recording capabilities, that you monitor them to make sure that they're working, that they have sufficient storage in order to store all of these conversations and all of these angles of capture. And the way the law reads, you as a store are not allowed to use that system on your own. You're supposed to keep it solely for the government's benefit, or if you receive a subpoena from a third party to access it. But for example, if on this expensive system you record somebody stealing, a gun bag or something, and you call the cops and you say, we had a shoplifter in here. And they go, oh, you got all those cameras. Can I get the footage? You're supposed to go, no, you can't. You have to go get a warrant in order to get that footage. I can't voluntarily give it to you. I can't even look, as the gun store owner, I can't even look at the footage to see who it was, to provide you a description if I need to go to the video. So what it really does is not only does it impose this great cost, but it basically hijacks your audio equipment, your video equipment, portions of your store where you have to hang the cameras, purely for government use. There's no self-use.
I would think that's just got to be so problematic for the income and revenue of these FFLs, having to front a bunch of money for surveillance systems and storage for a camera system that they can't even use for themselves. So I guess just to put a bow on this, you got a lawsuit. We did not get the decision we were looking for from the federal district court. The complaint has now been refined, and we are appealing it to the Ninth Circuit. Where do you see it going from here? And as always, I know that this is always a little bit more ambiguous. Any kind of timetable on this in your eyes?
Well, yeah, and to clarify, it's not on appeal yet. So what we have done is entered into an agreement with the state and with the court to allow us to file an amended complaint. So we're going to proceed, and the state is going to attack our amended complaint on another motion to dismiss, but we're still at the district court level. Now, what we're alleging in the amended complaint is our First Amendment claim that this chills expression, it chills association. We're also continuing to allege our takings claim, which is that you are hijacking our property through both regulation and in actuality by making us mount all this camera stuff on our private property. And then we're also alleging a Fourth Amendment claim, which is essentially that this camera system, although the state can only access it with a warrant, nonetheless, they're requiring recording 24 hours a day, 7 days a week. And for both business applications as well as specifically home applications, that violates the Fourth Amendment. That's a sort of warrantless search, even though they have to go get a warrant at a later date, that nonetheless it's impermissible. So we're still going to proceed on those three claims. The state's going to file a motion to dismiss. It's going to be heard sometime in October. And then at that point, we'll find out if the court is going to find that the claims have no merit at that point. The standard is a little different on preliminary injunction than it is on a motion to dismiss. It tends to favor the plaintiffs, our side in this case. So there's a possibility that some or all those claims may survive the motion to dismiss. And at that point, we would do some discovery into issues such as, what the state's governmental justification for this is, how they think it's going to promote gun safety, things like that. But the court could dismiss it, all of it, at this on this next motion to dismiss, at which point we would then file an appeal.
Gotcha. Well, definitely something to follow along with. This is a really intrusive law that was signed a couple of years ago. So definitely important for us to keep fighting this. Josh, I know you're a busy guy, so I want to thank you for coming down to talk with us about this. I appreciate it.
Thanks for having me.
Absolutely. And guys, if you like content like this and want to continue seeing videos on 2A litigation, please, as always, like, share, and subscribe to these videos. It really helps with the algorithms to get this message out there, especially coming into an election in November where we have the opportunity to get the right legislators in office. Thanks again, guys, and we'll see you on the next one.